Can a reverse mortgage lender foreclose if the family or estate was not properly notified? And is there anything that can be done after the sale? A reverse mortgage lender can foreclose once the loan becomes due, which often happens after the borrower dies. But the foreclosure still has to follow the required notice and hearing process. In a typical power of sale foreclosure, the lender or trustee must serve a notice of hearing on the parties who are legally entitled to it, including the record owners whose interests would be affected. The clerk can only authorize the foreclosure after a hearing and after finding that proper notice was given. Reverse mortgages also have an extra requirement: at least 90 days notice of intent to start foreclosure after the repayment obligation is triggered. If required parties did not get proper notice, there may be a way to challenge the foreclosure, especially if you act quickly. Timing matters because after the sale, there is an upset bid period of 10 days after the report of sale, and that window can repeat if an upset bid is filed. Once the upset bid period ends and the sale becomes final, undoing the sale is usually much harder, and the realistic focus often shifts to damage control. Even if the sale cannot be reversed, the estate may still be entitled to any surplus money left after the foreclosure costs and the reverse mortgage debt are paid. In some situations, surplus funds are paid to the clerk when it is not clear who should receive them or when the owner has died and there is no qualified personal representative. So it can be important to review the foreclosure file, confirm whether notice was properly served, and make sure the estate claims any surplus proceeds through the clerk's process.